Next, don't you do that? It's like, I don't know. I don't know. In half of it is I don't know. We got. That's the wrong. Please, I don't know. 3 weeks time we will. It does the wrong.
May I please, Your Lordship? My Lord, I beg to mention item number 8 on behalf of LD Sanctum Additional AG. My Lord, kindly list the matter after 2 weeks.
Inform the counsel for the petition.
Yes, Your Lordship.
Okay.
My Lord, 3 weeks may be granted, my Lord, to file affidavit.
Your miss,
Shista Jamir, Your Lordship.
then counsel for the petitioner is present. Start. Mr. You are mentioning on behalf.
On behalf of LD Sanctum Additional AG.
Okay. Mentioning on behalf of LT Sanctum, that additional AG, praise for
3 weeks time.
adjournment of the matter for 3 weeks.
Yes, my Lord.
Prayer not objected. Start. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
My Lord, again, I beg to mention item number 28 on behalf of Livica. Kindly list the matter after 2 weeks, my Lord.
28.
Yes, my Lord.
Mr. Limau. Made a mention. And here also have you informed?
Yes, Your Lordship.
Yes, my Lord.
Okay, similar order then. You have mentioned
2
on
weeks.
behalf of
Livica.
Livica, okay, on behalf of Livica, similar order. Okay, 2 weeks,
Yes, my Lord.
you have 2 weeks.
Much obliged.
Lordship, I would like to mention item number 33 from hearing list, Your Lordship. 33, Your Lordship.
33.
On behalf of P. Chanda. Your Lordship, kindly fix this matter after 4 weeks, Your Lordship.
Each under is for petitioner.
Yes, Your Lordship.
It's a fixed matter. Have you informed the other side?
Yes, Your Lordship.
Hmm?
Yes. We were informed by B. Chanda that he have already informed Your Lordship.
Informed by?
B. Chanda.
Each under is for the petitioner.
Yes, Your Lordship.
Have you informed the other side, the respondent?
He have informed the respondent.
Respondent also?
Yes, Your Lordship.
Okay, Miss
Shista Jamir, Your Lordship.
appearing on behalf of Mr. P. Chanda, counsel for the petitioner with the consent of the other side. Praise for listing this matter after
4 weeks.
4 weeks. The prayer is allowed. List this matter after 4 weeks. Okay.
Bless Your Lordship.
My pleasure, Lordship. I beg to mention item 23, hearing item. Here, in the previous occasion, I made a submission that the accused is dead. So to bring into into record, I sought permission to file affidavit, additional affidavit. However, we're yet to get proper instructions, so some more time may be given to me.
You are for?
For the accused. Since
Accused
they,
is no more.
yes, yes.
It can be abated then.
I leave it to your Lordship if we have the death certificate here. However, we are
Okay.
yet to
You have a
translate.
death certificate.
Yes, it's
Please,
in this script.
Item
23.
23 is NI case.
Oh, 22. My apologies. Lordship.
Who is for the petitioner?
Yes, Your Lordship. I'm appearing on behalf of EASO.
Okay. Mr. Yeah, Mr.
James Newman.
Counsel for the applicant. Also hardness.
Rohit Sakra, Lordship.
Land Council appearing on behalf of
Accused, main
the
accused.
accused respondent staff. Miss, her name, huh? Submits that during the pendency of this appeal, the accused, what is his name? Samrat
Kamrat, yes.
has expired on 24/7/2024. In view of the above, this appeal is abetted on the date of the deceased. Hello. Yes, item 22. He was convicted ultimately,
Yes, no,
convicted by this court.
no lordship.
No, no.
He was acquitted.
But then this court again convicted.
No, this court gave a direction to rehear.
No. It was not for here. Hearing on sentence only.
To resentence the accused.
Yes, sentence only.
Yes,
Yes, he was. But to hold the accused guilty of having committed rape on the prosecuted, which is punishable under section so and so. Commission of so and so, which is punishable under so and so. In view of the fine, the conclusion needed to say that the judgment of so and so is overruled and the accused is held guilty of the offense punishable under section 376 and section 506 of IPC. Yes, he was. Can a copy of this order to the land system judge for him up. On receipt of sentence. Shall be fixed date for sentence. Directed the session judge to fix date for sentence on this. However, the conviction of the accused shall remain effective. Although although hearing on sentence could not be done due to the death of convict. So, what happened? After this incident, whether the victim has received any compensation?
Lordship, I'm not well aware of the facts as I'm only a proxy counsel.
Okay.
Lordship, after the passing of this judgment, the accused went to the Supreme Court for appeal.
The Supreme Court
Yes.
only says
And
the
if-
impugned order of the High Court is set aside to the extent it has directed the session court to pass an order on sentence. Only about a sentence only.
Yes.
Sentence is to be passed by this court, what the Supreme Court says.
Yes, yes.
The High Court shall hear the appellant accused on sentence and pass the appropriate order.
Yes,
Conviction retained and then upheld conviction, and then only the sentence was to be passed by this court.
yes.
So conviction that remains. Okay, fair enough. In this case of
2016.
2016. The victim is entitled for compensation under the victim compensation scheme. Yeah, under the victim compensation scheme of the state. So let a copy of this order be forwarded to the member secretary, legal services authority, Nagaland Legal Services Authority. No. Not member secretary, the chairman, secretary, legal services authority, Kohima. District Legal Services Authority, Kohima. Not member secretary. For forwarding the case of the victim for compensation under the victim compensation. Under a scheme of the victim, under the victim compensation scheme of the Legal Services Authority. With the above this appeal stands disposal.
Next question.
Please, Lordship.
Yes,
Lordship, I beg to mention hearing item number 25, 26, and 27. Lordship, my senior is indisposed. So I pray that this matter come up on Tuesday, 26.
therefore,
I'm for respondent number 9.
respondent,
Lordship.
who is for the petitioner? Have you?
Lordship, I'm for the petitioner.
Petitioner.
Yes, Lord.
No,
No objection.
okay. Miss
And approve.
Land Council submits that our senior is indisposed. And pray for adjournment of the matter. For
26,
oh,
Coming
you want
Tuesday.
this matter to be fixed,
Lordship.
okay. For the day and to fix the matter on 26. To which the land counter for the petitioner has no objection. Prayer allowed. List this matter on 26. Okay.
Pledge, Lordship.
Yeah, please, Your Lordship.
Yes.
I would like to mention item number 23 and 24. Lordship, since I'm appearing on behalf of Mr. Siddharth. Since he's an outstation counsel, he couldn't be here today. He also seeks for two weeks time.
Mr.
Donato.
No objection.
Lordship, my senior, Mr. Logesh, is appearing on VC, but the light is not very good enough. But his appearance may be reflected, Lordship, from NIA, Lordship.
You're taking adjournment. sir.
Yes, Your Lordship, I'm appearing for NIA PP Lokesh Kumar.
Okay, the land council for the appellant is seeking adjournment for the day.
Your Lordship, on the last day, the TCR trial court records were called from the trial court, but I think it's not sent by the trial court.
Okay. So in any case, then can be adjourned.
Please, sir.
Mr.
Donato.
appearing on behalf of Ellen Misra. Praise for adjournment of the matter for 2 weeks.
I'm appearing on behalf of Mr. Siddharth Burgoyne,
Siddharth is for?
petitioner.
No. Where is Siddharth? In
Oh, items 23 and 24. It's not reflected on the cost list.
Is there?
Lord, NN Mishra is for the NIA Lordship.
Is it?
Lordship.
IA is filed by, okay,
NIA
NIA.
Lordship. Lordship.
okay, then in the writ petition, Tongpo and the Susan. Siddharth's name is not there?
It's not reflected on the cost list.
Yes. Okay, appearing, then whether Tongpo Kongner is appearing on behalf of the petitioner? No, he is not.
My lord, previously, this name restricted is not the main petitioner. Paul Cohen is the main petitioner. Although his name is not reflected in the cause list.
Lordship, counsel for the petitioner is Mr. Siddharth Burgoyne, whose name is not reflected in the
Appearing on
causes,
behalf
Lordship.
of Siddharth,
Burgoyne.
praise for adjournment of the matter to which the land council for the respondent has no objection. Prayer allowed, list this matter after 2 weeks. Okay.
Obliged, Lordship.
Lordship, I would also like to mention item number 14. Lordship, in the last order, this court would allow I have
14 is in order, wait for some time.
Yes, Lordship.
Okay,
May I please, my lord?
yes,
Lordship, I beg to mention item number 13.
yes.
Lordship, I am here to file my counter affidavit in this matter. If some time can be granted, your lordship.
Mr. Hirado, Hirado, land council for the petitioner is present. Mr. Land council appearing on behalf of the state respondent, praise to father
4 weeks time, your lordship.
4 weeks time to file affidavit.
Yes,
No.
ma'am.
The prayer is allowed, list this matter after.
Lordship, there's an interim if that may be continued.
Stop, para. The interim order passed earlier, so continue to the next date. Okay.
Your Lordship, may I also be allowed to mention item 5. Here I have received the counter filed by the state this morning. If I may be granted 4 weeks time to file an additional affidavit in reply.
Item 5, huh? Mr. Elirado, sorry, Elirado. You are L.
Earlier than.
And also for the petitioner. Submits that he had just received the counter affidavit filed by the state respondent. And prays for how much time?
4 weeks time.
4 weeks time to file, reply, affidavit in reply to the counter affidavit so filed by the respondent. Prayer is list is matter of the 4.
There's an interim here also.
Stop, para. The interim order passed earlier, so shall continue to the next date.
I'm obliged.
Deeply obliged, my lord.
May I please, your lordship? Lordship, I beg to mention item 9.
Next,
Yes, on behalf of AIME, government advocate. We pray for 3 weeks to file our
then-
AIME. 3 weeks
Lordship,
to
I'm for the
file our
petitioner.
affidavit.
your
Yes.
petitioner.
Yes, Lordship.
So, you are AI,
For, on behalf of AIME, your lordship.
okay,
Yes. We pray for 3 weeks to file our affidavit.
okay, Mr.
M. Longcomer.
Appearing on behalf of Mr. A,
AIME, Miss AIME.
Ms. Land Council for the state respondents. Praise for father, how much time?
3 weeks, your
3 weeks
lordship.
time to file affidavit. So, you are Miss
Vikono Kiso.
Land Council for the petitioner as present. Is prayed for comments. The further 3 weeks time is granted to the state responding to file counter affidavit. List this matter after 3 years. Okay.
Your lordship, I have a similar prayer for item 10.
Then,
Yes, your lordship.
yeah, you are for,
For the state respondents, on behalf of AIME.
okay, then,
Lordship, I'm for the petitioner.
there is your good name,
Noklay M. Konyak.
Mr. Appearing on behalf of Mr. on this line council on for the state respondent. Praise for the previous time to file counter affidavit. So, Mr.
Noglay M. Konyak.
Land council for the petitioner is also present. Please pray for for the 3 weeks time is granted to the state respondent to file counter affidavit. Okay, list is matter after 3 weeks.
Your Lordship, I also have a similar prayer for item 11 on behalf of Ms. Inaholi.
Okay, now
Yes, Your Lordship.
similar order, and you are here.
VC, Your Lordship.
V. Shiri, huh? The council name will change, V. Shiri. Okay, rest will sir. Listen. Okay.
Your Lordship, I'm for respondent number 5 AG.
Here,
Yes, Your Honor.
in item 11.
Yes, Your Lordship. We have filed our affidavit in opposition this morning. I'm sitting on behalf of my senior Joshua Shiki.
Okay. And Mr.
KVQA.
Land council for the.
On behalf of
respondent
my senior Joshua Shiki.
number. Okay,
Respondent 5,
appear on behalf of Mr.
Joshua Shiki.
Seki. Land council for the respondent number
5, Your Honor.
5. Okay.
Your Lordship, I also like to mention item 12 on behalf of the channel. We have received instructions, but we have asked for further instructions. So we pray for 3 weeks, Your Lordship.
Here you are carrying on behalf of
On behalf of Ms. Pichano.
her name is there. Okay, Mr.
Government advocate.
Okay. Appearing on behalf of Ms. Pichana.
Your Lordship,
Land.
Your Lordship, I'm for respondent 5 to 11.
Okay. Respondent number
5 to 11.
5 to 11.
Yes, Your Lordship.
Okay. Have you filed affidavit?
No, Your Lordship. We're yet to.
Okay. Pichana and Miss
One channel, Minjay.
Wangcha
One channel, Minjay.
Homso. Land council for appearing on behalf of respondent number 5 to 11. Praise for father. How much time?
3 weeks, Your Lordship.
Father 3 weeks time to file affidavit.
I'm for a petitioner,
Mr.
John.
John P. is on land council for the petitioner is present. So it's prayed for by the respondent comma. List is matter after 3 weeks. Okay.
Much pleasure.
Your Lordship, I'd like to mention item 21 on behalf of S. Chang. You're yet to receive instructions, so we pray for 3 weeks, Your Lordship.
So whether the petitioner is present here,
We have informed them, Your Lordship.
inform.
Yes, Your Lordship.
Okay, Mr. His name again. Appearing on behalf of Ms. Chan, land council for the state respondent. Praise for father.
3 weeks, Your
3 weeks
Lordship.
time to file affidavit in opposition. He has obtained a consent from the council for the
Petition.
petitioner also. So accordingly, the prayer is allowed. List is matter after 3 weeks. Okay.
Obliged, Your Lordship.
Lordship, I beg to mention item number 18.
It is 18.
Yes, Your
It is
Lordship.
in the order. Wait for some time. We'll pass it. Adjourn, but wait. Huh? Okay.
Yes, Your Lordship.
I appreciate Lordship. Lordship, I beg to mention item number 4 on behalf of my seniors and the young Lordship. Lordship, here we are yet to file affidavit in reply, so kindly grant us 1 week time, Your Lordship.
Mr.
Noglay M. Konyak.
Appearing on behalf of Mr. Senkyang, land council for the petitioner. Praise for how much time?
1 week time, Your Lordship.
1 time to file affidavit in reply. The prayer is allowed. List is met after a week. Okay.
Lordship, I also beg to mention item 7. Similar prayer, Lordship. Here we are, the affidavit is ready, but we are waiting for the signature of the petitioners, Lordship. So kindly grant us 1 week time.
There was affidavit in reply.
Yes, Your Lordship.
Mr. What was your name?
Noglay M. Konyak.
Appearing on behalf. Your name is there?
No, Your Lordship, I mean
Appearing on behalf of Mr.
Sentyang.
And counsel for the petitioner, some Mr. The affidavit in reply is ready, however, the prepared, but the affidavit is to be signed, no? The affidavit is yet to be signed by the Land Council. By
Petitioners.
the petitioner, and prays for further one at a time. Prayer allowed, list is never after the week.
Lordship, I also beg to mention item number 17.
17 is in order, let us see the order, and we'll adjourn, but wait for some time, okay?
Lordship.
Let us see the last.
May I please, your lordship, I beg to mention item number 30 on behalf of the council for the petitioner. Your lordship, the council has some personal difficulties
Which
today.
item?
Item 30, your lordship. 30, yes. The council has some personal difficulties today. So if the matter could kindly be listed after 2 weeks.
Petitioner,
Yes, your lordship.
Miss
And solo for the council for the petitioner, Lucino.
Council, council submits that the leading counsel for the petitioner, who is Rosino,
Yes, your lordship.
has some difficulties today and pray for adjournment of the matter for the
2 weeks, your lordship.
matter for 2 weeks. Prayer is allowed, please matter after 2 weeks, okay.
Much obliged.
Please, my lord. Also, I beg to mention item number 6 on item 6 on behalf of respondent 2 and 3. Lordship here, kindly allow us 2 weeks time to file our affidavit in opposition.
Who have you informed the petitioner? Right?
Lordship, may this be the last opportunity. Lordship.
Mr. You are Mr.
James Newman, for
Counsel
petitioner.
for the petitioner is present. Mr.
No, sir, on behalf of respondent 2 and 3.
Land Council for the respondent number 2 and 3.
Lordship.
Pray for
2 weeks time, Lordship.
further 2 weeks time to file affidavit in opposition.
Lordship.
Last chance has been given. For 2 weeks, 2 weeks time is granted to the respondent number 2 and 3. There's a last chance to file affidavit in opposition. Please this matter after 2 weeks.
2 weeks, Lordship.
Okay.
Obliged, Lordship.
For admission, item numbers 1 and 2.
Maybe, Lordship. Lordship, kindly grant me 3 weeks time to file my reply, Lordship. I've taken the consent of the
Reply not yet filed.
Lordship, not yet filed, Lordship.
Mr. Sigopote, Land Council for petition, prays for further 2 weeks time. To file affidavit.
3 weeks, Lordship.
3 weeks time to file affidavit in reply. Mr. Angam, Land Council for the state respondent is also present.
Lordship, here it's not state.
Here, yes,
It's not
yeah,
the state.
yeah, in team song is appearing.
Corporation.
It's for the corporation, your lordship.
Okay, in teams.
Yeah, yes.
You are not appearing.
No, your lord, I'm standing on his behalf only. He's on his leg at code
Okay.
number 1.
Okay, then the prayer not objected. Accordingly, the prayer is allowed. Please this matter after
3 weeks,
3
Lordship.
weeks. Okay.
I'm deeply obliged.
Obliged, my lord.
For admission, item number 3.
This item 1 is with 2. 1 and 2. Okay.
Wait, please, Lordship. My lord, here, I'm yet to file my reply against the failing opposition of the respondent. Well, only 3 weeks time, my lord. To file reply on the
And Land Council for that
petitioner, my lord.
petition. Prays for further how much?
3 weeks time, my lord.
Further 3 weeks time to file affidavit in reply to the affidavit filed by the
Respondents, filed by the respondents.
respondent. The prayer is allowed. List this matter after 3 weeks.
Most obliged.
For orders, item numbers 14 and 15.
Lordship, I'm appearing on behalf of Mr. H.H. Kinimi. Lordship, he couldn't be here because of some personal difficulties. However, he will be filing his IA today.
IA for what?
I have for amendment of the writ petition, Lordship.
Affidavit in opposition already filed.
Lordship. I am for state respondent, 1, 2, 3.
Okay, you are for state respondent.
Lordship.
You have already filed affidavit in opposition.
Lordship.
Okay, why you are filing IA?
Lordship, in the last occasion, there was some error in the IA, so the court was gracious enough
There
to
is
allow
error
in the IA.
You have filed IA. IA for what?
Amendment of the writ petition. Of the writ petition.
After receipt of the affidavit. Who is praying for adjournment?
I'm the petitioner.
You are Mr.
I'm appearing on behalf of Mr. H.H. Kinimi.
You are Mr.
Donato.
Appearing on behalf of Mr. H.H. Kinimi, Land Council for a petition sought for adjournment of the matter for
2 weeks.
2 weeks, to which the Land Council for the respondent has no objection. Prayer allowed. List is matter of the.
Lordship, there is an interim.
The interim was also continued to the next.
Much obliged.
Lordship, my apologies. In the earlier item number 23 and 24, there is also an interim.
Here one, they made an adjournment prayer. So, in that case, the interim or the past earlier shall continue till the next stage.
Much obliged.
For orders, item number 16.
Please, Your Lordship. Where's the last order? Your Lordship, the notice upon the union respondent was complete. When this Honorable Court again gave another direction to send a fresh notice, my lord. So here, this application is for appointment of an arbitrator. So, my lord, it's not an application that should be kept pending for long like this. In any matter, Your Lordship, since there was a direction to again issue fresh notice, and I do not know whether the notice has returned or not.
Service report awaited.
Return service, still awaited. No, my lord, the first notice was complete. So, my lord, it appears to show that they are not interested to appear in the case. And this cannot continue because they have already received a notice, my lord.
The first notice was received by them earlier.
Yes, Your Lordship, may I take Your Lordship to the order dated 1/10/2024. Yes, my lord, on the order dated 1/10/2024, may I take Your Lordship to the second page, the second paragraph, my lord. Office note dated 26/9/2024 states that tracking report of notice issued upon the respondent number 1 from India Post website shows item delivered, addressee. There is, however, no representation on behalf of the respondent number 1. So, my lord, when the item is already delivered, it appears to show that they have no regard for the proceeding before this Honorable Court. It amounts to disregard to the proceedings before this Honorable Court. And it's just for appointment of an arbitrator, my lord. So, a petition has been kept unduly and unreasonably pending for such a long time, my lord. So, we may be allowed to maybe give a substitute notice And if they do not appear on the next date, but in this case, your lordship, their appearance is also necessary, so at least a personal appearance may be called for, my lord.
Even after receipt of the notice. But we do not know whether they have received or not. It's delivered, but then.
But when the item is delivered, this is through,
Yes, of course, delivered.
my lord. It's not through some unknown sources. It is through a reliable source, that is India Post, my lord. So India Post would not make up a story to say that the notice has been delivered, my lord.
But on your prayer only.
No, it was not on our prayer, your lordship.
No, but it's may be allowed to take fresh steps.
Unfortunately, it was recorded that way, your lordship. If not, when the notice is complete, there is no question of making another submission for issuing fresh notice, your lordship. It leads to undue delay of the matter, your lordship. My lord, if the return notice is still awaited,
Now, what do we do? You want to take?
my lord, I have a request which my lord may kindly record it in the order, my lord, that upon receiving that the notice served upon the respondent number one is again, if the same report comes back that it is delivered, a complete service delivered notice, if the same is received by this registry, and on the next date, if they do not appear, my lord, the secretary concerned or the authority concerned, my lord, may be personally summoned to appear before the Zombie Court, my lord. Because after the notice is delivered and not appearing, your lordship, this is the MOTH represented by the Secretary, Ministry of Road Transport and Highways, Zone NE.
How many respondents are there?
My lord, there are two.
So these service is upon both the respondent.
No, the state, my learned friend is
Lordship,
appearing.
yes, for the state respondent is a chief engineer, National Highway.
Okay.
We have already filed an affidavit raising objection. Because in before the amendment of this arbitration petition, there was the MORTH was not impleted. And the project belongs to MORTH. We are just to implement the project. And therefore we have raised the thing, and then the petitioner hearing has filed an IA by impleting the MORTH now, who is made as respondent number one in the amended arbitration petition, your lordship.
Okay.
My lord, by default, MOTH was actually a party in the case because MOTH executed an agreement which was represented by the chief engineer PW National Highways. So they were in the picture, but in the meantime, a new development took place where MOTH, they washed their hands and then they gave the responsibility to the state. So that way they had, though if we go by the contract agreement, impleting the chief engineer is it amounts to impleting the MOTH also because he was made the representative. But when the MOTH has washed off their hands and the responsibility was cast upon the state, it's like there was a divorce in their marriage, and they had to be made separate parties, your lordship.
Okay. Very hard divorce, in fact, your lordship. Now, in fact, your lordship, by an order dated 2nd of May 2024, the MORTF has actually cancelled the project, and they have sent it to the secretary, Work and Housing Department, National Highway. So everything,
Yes,
your
your
lordship
lordship.
is finished now.
No, because
The
of that,
contract
we have to
agreement,
make
everything.
both of them as separate parties, your
Yes,
lordship.
now.
Anyway, so Mr. Joshua Seki,
My lord.
Land Council for the position. And Mr. Nangan. That is, for the responding numbers.
Two, my lord.
the office, no, sorry, the order dated 1/10/2024 reflect. Not. Office note dated 26/9/2024. Reflect that tracking report of notice issued upon the respondent number 1 from India website source item delivered within bracket address bracket close. However, on 1/10/2024, the land counsel for the petitioner prays for allowing to take fresh steps for service of notice upon the respondent number 1. And accordingly, a step has been taken, a fresh step has been taken by the registered post with AD. However, the office note dated 6/11/2024 reflect that the service report is still awaited. As stuff back, as the notice has already delivered to the addressee as reflected in the office note dated 26/9/24. You want to take substitute, sir, because if you think that they are necessary parties, substitute service, you want to take or no?
Will we be allowed to give dusty service, Your Lordship?
Dusty.
Yes, Your
Then in
Lordship.
that case, that may also not be, okay. Then this may not be also required then, in that case, if you want to take fresh steps by way of dusty service.
Perhaps dusty service would be the most reliable, my lord.
That was not necessary, required. I thought that. Okay, then leave that. I don't know. The office note date is 6/11/2024 reflect that the service upon the respondent number 1 is still awaited. Start in view of the above, the land counsel for the petitioner. From this step, he may be allowed to take first steps upon the respondent number 1 by way of by dusty service. Okay. So the petitioner is allowed to take steps upon the respondent number 2 by a dusty service. So to be routed through the registrar of this court within a week, within 2 weeks.
Within a week's time, Your Lordship. Within 1
Is it
week.
possible?
Yes, Your Lordship.
Okay.
Will once the paper is ready here.
Okay, within a week from
Yes, Your Lordship.
today and file affidavit to the. Least it's matter after 2 weeks then.
My lord.
That will be better.
Oblige, Your Lordship.
Deeply obliged.
For orders, item number 17. I wish, Your Lordship. Lordship, we would like to file a short affidavit. Yes, Your Lordship. Within 2 days, Lordship. So it may be listed Friday also.
Lordship may kindly examine whether the petitioner met out any contempt case or not. That is the only issue, Lordship. Once the contempt petition is filed, affidavit in reply, affidavit in opposition, whether that is necessary or not, this honorable court may kindly examine. Lordship, what happened, Lordship?
You file affidavit.
I file my affidavit in opposition as well as complaints affidavit as directed by this court, Lordship.
Okay.
So by filing reply to my complaints affidavit, Lordship, the allegation of contempt made by the writ petitioner will not improve, Lordship.
Reply affidavit to.
Nothing left now, Lordship. Nothing left.
Yes, Lordship.
Reply affidavit to.
Compliance affidavit
I
filed
filed
by
a
the,
complaints affidavit, Lordship. I file and read.
Is it necessary?
Not necessary at all, Lordship. Lordship, may kindly see the court's order dated
Compliance.
3/10/24, 3/10/24. The order passed by this court. On 3/10/24, 3/10/24.
Yes.
Yes, Lordship, pardon. Why this honorable court passed this order, Lordship? The reason is the writ petitioner and the contempt petitioner have made an allegation that the respondent number 2, I'm referring for respondent number 2, have issued a verbal instruction to a particular union not to invite him. That is the only allegation, verbal instruction. There is no proof that the respondent number 2 acted in violation of the court's order. Therefore, Lordship, taking into consideration of the unfounded allegation and in the interest of justice, Lordship, this honorable court passed this order, directing me, the counsel referring for respondent number 2, to give advice to issue a letter to the concerned union. And accordingly, Lordship, next page. Page 8.
Of your. Page 8 of.
Oh, Lordship, page 8 of my
Complaints
complaints affidavit, which was filed on 23/10/24.
Yeah.
Page 8, Lordship.
Yes, correct.
May I read, Lordship?
Yes.
To the President Kohima Chungja Sinso the Longjam. Respected letter, we bring greetings to you through the village council. Through this letter, we convey a vital aspect as resolved in the village council meeting. As we all know, there is excommunication of Shri Chalokhamba, that is the petitioner, from Chungdia citizens. White Village Council decision dated 30/6/2023 has been held illegal by the Honorable High Court and held that he can remain in his village without any social boycott. In view of the Honorable Court's order, Mr. Chalokhamba is considered and is being treated as a bona fide citizen of Chungdia village till date. However, Mr. Chalokhamba again approached Honorable High Court alleging that he has not been invited to any meetings of Kohima Chungdia Citizens Union and also excluded from annual membership fee collection. The village council therefore informed that Mr. Chalokhamba is a bona fide Chungdia citizen. As such, he is right to be a member of your union and to subscribe annual membership fee as well. And he must be treated as a bona fide Chungdia citizen. So this is pursuant to this honorable direction, Lordship. I don't know what type of affidavit and reply do you want to file. No contempt has been made out in this contempt petition, Lordship. However, Lordship, it is not proper on my part to argue in absence of his senior counsel, Lordship. Therefore, Lord, matter may fix on day after tomorrow for disposal.
So till day after tomorrow if you want.
Yes,
Day after
Lordship.
tomorrow is a Thursday,
Trustee, Lordship.
Lordship, it may be fixed on Friday.
Friday.
Lordship.
Let's grateful by the land council for the petitioner. List is matter on Friday. Mr. What is the Milan council for the respondent is also Friday.
Deputy Operator.
Obliged.
For others, item number 18.
Please, Lordship.
Yeah.
Lordship, I'm for respondent number 2 and 3.
No one appears on behalf of the petitioner.
Yes, your Lordship.
No one appears on behalf of the petitioner on call. Miss
Nagalisho, Lordship.
Council for the respondent number.
2 and 3, Lordship.
Is present. The office now. 24, 29, 24, 24. The copy of the trial court record is received. The trial court record. Oh. This just matter for admission period after 3 years. Okay.
Much obliged, Lordship.
For others, item number 20.
Please, your Lordship, item number 19 has not been called.
My lord, I beg your pardon. Item number 19.
19. May I please, your Lordship?
Yes.
I'm appearing through VC. Your Lordship, as per the last order in this item number 19, make appeal, 17/10/24. Sir, Lordship, the service upon all the respondents were still awaited. So if your Lordship will please look into your record what it says, or else direct us. Last order was 17/10/24.
Petition. Okay. Mr. You are Mr.
Satish Konwar Chetri.
That is Kumar Chetri. The office note dated 26. 17/10/2024 reflect that the service noted upon the respondent number 1, 2, and 3 are still awaited in view of the above. List is matter after 2 weeks.
After 2 weeks. Much obliged, your Lordship.
For others, item number 20.
May I please, Lordship. Lordship, notice upon respondent number 1 and 2, Lordship 1 and 2 is represented by my learned friend, Mr. D. And Lordship, with respect to respondent number 3 and 4, Lordship, I may be allowed to take a paper publication, Lordship.
Who are these?
3 is the owner of the motorcycle, and 4 is the driver of the motorcycle.
And your claim is against?
I'm for the insurance, Lordship.
I'm for the respondent claimant, Lordship. Lordship, I filed my Vagalatnama yesterday, Lordship. So it has not been reflected. Only yesterday.
You have challenged the
Yes, Lordship, I've challenged the
award.
award.
So this is basically whether the respondent number 2, other respondent 3 and 4 participated in the tribunal, before the tribunal. Are they necessary party?
Lordship,
Your basic claim is against the claimant.
Lordship, in the lower court, they have entered their appearance and contested the claim, Lordship.
Yes,
They are necessary party in
they are
fact,
necessary party.
Lordship.
Then we have to wait for some more time.
Lordship.
You have an objection?
Yes, Lordship, there is more than 1 year delay in
Yes.
filing these appeals, so we'll also be filing objection, Lordship.
Okay. Mr. Patel, Direct Counsel for the applicant. And Mr.
Imti Wapang, Lordship.
Direct Counsel hearing for the
Respondent
number
1 and 2.
1 and 2 claimants. The service of notice of number 3 and 4 are still awaited. In view of the above. When it was taken, I think,
Lordship, it was taken on 25th 9.
what do we do? You want to
Lordship,
take further steps?
Lordship, instead of taking fresh steps, Lordship, I may be allowed to take a substitute notice by way of a paper publication, Lordship.
Okay.
One, the owner is a resident of Arunachal,
Okay.
Pasigat,
Okay.
and the other is from Lakhimpur, Assam.
Then, right, in view of the office note dated 26/9/2024, come. The Direct Counsel for the applicant. Promise that he may be allowed to take a substitute and a notice upon the respondent by way of substitute. By way of substitute.
Public notice,
Okay.
through paper,
By-
through paper publication.
For publication. So. The prayer is allowed. Petitioner, so the applicant shall take steps upon the respondent number 3 and 4 by publication in the local newspaper. Where in at Arunachal Pradesh,
Lordship, Arunachal Pradesh.
2 or 1 local newspaper?
Local, Lordship, one will do
One.
for 2 days.
You know, and what the name of the paper?
Lordship, I am not aware, Lordship, but I'll find out, and when I make
Okay.
they take the notice from the registry, I'll note it down, Lordship. So one local paper for 2 consecutive days. One in Assam and one in Arunachal.
Newspaper in Assam. Assam is the respondent number?
4, Lordship.
So respondent number 4 and in Arunachal in respect of the respondent number 3. And within
Lordship, within 4 weeks, Lordship.
Within-
At least take some time, Lordship, since it's Arunachal.
4 weeks from today. uh, For 4 weeks from today and file affidavit to that effect. No, within 4 weeks from today by fixing next date of the case. We have to fix the next date,
Let's say, Lordship, in the month of January, Lordship.
January, fixing next date of the case on January.
Lordship,
Right.
I know that when the court will be reopening, but Lordship on January,
21,
on 21st of January, Lordship.
if it doesn't fall Saturday on holiday.
Lordship.
Hmm? Okay. Fixing next date of the date of the appearance of, by fixing the next date of the case on 21st
21st of January, Lordship, 2025.
and file affidavit to this effect.
Lordship.
List is matter on 21st. 21st is, okay.
Lordship.
Highly obliged, Lordship.
Bless my Lord.
For hearing, item number 29.
May it please your Lordship. My Lord, we have one partner matter,
Yesterday's matter.
yesterday's matter.
This is 20.
That is item number 32,
I think
It is
Partner
listed in the
matter.
item number 32.
34, partner matter.
What about this 29? Anyone appearing? No one appears on code. List is matter after 2 weeks. 29. Okay. No, 30, are they ready? Yesterday's part are matter we have.
My Lord, in respect of item number 31 and 32, my Lord, it may be adjourned for 2 weeks. I'm appearing for the respondent number 2 and 3. I have taken the consent of the appellants,
Okay,
Counsel.
31.
31 and 32,
And planning council for the respondent number
2 and 3.
and the consent of the planning council for the applicant. Raise for listing this matter
After 2 weeks, man.
after 2 weeks.
Lordship, I'm for number 1
Okay.
in both matters.
Your Lordship, I have for appellant.
You are for that.
For appellant, Your Lordship.
Okay. Okay, and here will come and council for the.
Respondent 2 and 3.
So listing this matter after 2 weeks, to which the land council for the applicant has no objection. Prayer and list this matter after 2 weeks. Mr. Pacheco for the land council for the
That's number 1.
respondent number 1, he's also present. Okay.
Lordship, I'm for respondent 4 and 5.
Respondent number 1 and Mr.
Imtichang for respondent 4 and 5.
also appear on behalf of respondent number 4 and 5. Okay. Are also present. Okay.
Obliged, Your Lordship.
For hearing from the supplementary post week, partner matter, item number 34.
Yes.
My pleasure. Malady, I have already submitted the irregularities committed by the Lower Appellate Court. Because in my plaint, I have prayed for very, very limited prayer method. In my plaint, that is the additional paperwork.
Okay.
In my plaint, to set aside the letter dated so and so, letter number so and so, dated 4/8/2004 by the Deputy Secretary Revenue Department, as well as for cancellation of the revenue dated 29/10/2004 issued by the Deputy Commissioner in respect of this claim. By these two letters, the restraining order was passed. And the government side has not stated anything in their written statement. And moreover, what they have stated, they have not adduced any evidence to prove their contents. And prayer number 2 is declaration of title of the suit. Well, I have read the issues by the appellate court. Now the issue number 17 and 18.
Issue number 10, 12.
Well, they
Dealt with yesterday.
yesterday. Whether this issue number 13, whether the collector, director, record survey of the individual for allotting or development of land manufacturing. Already patta number 71, tag number 172 block.
That is issue number
Issue, page 74,
page 74.
issue number 30.
Issue 13, issue number 13.
Yeah, whether the staff of the district collector and directorate of the land record and the survey and the individuals are allotting and develop their sites in the manufacturing by manufacturing and record and reports. 14, whether patta number 71, tag number 172, block 9 and patta number 1009, tag number 1134 of the shoot line measuring 1 kata 15 lasers are same. 15, whether the land falls in A26 an area of 2 kata 16 lasers, which the land belong to the dependent number 3. And whether the land belongs to dependent number 3 under DAC D26, which an area of land measuring 2 kata 50 lasers, which is currently under occupation of Sri Wapang Jamir, as per trace map submitted by the Apang Pagnir. But the 15 is the important, this finding of the issue number 15 at the page 161. Last paragraph on the bold letters. Issue number 15 is decided by holding, notwithstanding difference of tag number and patta number and the size of the land. It is the same plot of land claimed by the plaintiff, appellant dependent number 3 and the plaintiff dependent number 1. Plaintiff respondent number 1. Well, therefore, so far 15 is concerned, the learned lower appellate court has failed to come to a definite conclusion. Page 160.
What about the 14? Have we dealt with the issue number 14 yesterday?
Issue number 14.
11 and 13. We have dealt with 10 and 12.
Yes.
9, 10 and 12. 11 and 13, I think we are yet to deal with. What is the decision in, with regards to the issue number 11 and 13?
Whether the patta number and tag number sent in the resettlement resulted the confusion with title of the record of rights. And whether the survey of the competent authority survey report still submitted the report on 23/9/2002, forwarded by the government for approval in the issuance of the patta to the office of the Deputy Commissioner on 25/9/2002. Whether these issues are not so relevant for decision of this court. Our main case is this: we got the land, we are the owner and the title of the land, measuring 2 kata 16 lasers of tag number A26. And the defendant claimed that he is the owner of 1 kata 50 lasers of land of tag number D26. It is only the point is this, whether A26 and D26 are the same plot or it is a different plot. The survey report is clearly stated that these two plots are different. If these two plots are different, as per survey report I have already placed before your lordship yesterday. Then, my lord, the case, there is no case against for the defendant because their land is different, our land is different. And our main prayer in the suit is for cancellation of the order issued by the government, restraining order. So far title is concerned, it is as per survey reports, it is clear.
So while deciding this issue 14/50/19, the finding, the lower appellate court says that finding of the trial court is totally erroneous.
My lord, this finding is absolutely incorrect because the learned law appellate failed to go into the root of the case. What is the prayer of the plaintiff?
You can observe that if the claim related to land situated at two different places, there would have been no dispute at all.
Yes.
But then since it appears that the claims are with, both the claims are on the same land.
The survey report stated that these two are different. And therefore, we have challenged the government order, restraining order.
And also says that the government has cancelled the approval for allotment of land to the plaintiff. It was because of the duplicacy of patta against the same plot. Says that it was same plot.
Page 17, Srimati Lerenikinan Dimapur town is hereby allotted settlement of a plot of land measuring 2/6. Yes.
So that what the trial appellate court says that the duplicacy. That is duplicacy.
These 2/6 lessons were allotted to the plaintiff. Yes, sir. Yes, well, I have the plaintiff has challenged these two orders that I have exhibited. The cancellation of patta, that is page number 114 and 115. Oh, sorry, 184. 184 and 185. I am directed to refer
What is this 184 cancellation? Okay.
cancellation of government approval allotment to Larini Kikon. I am directed to refer the letter that so and so subject cited above, and to say that the approval of allotment of land to Larini Kikon in block number 9, measuring an area of 2/16 lesses is hereby cancelled
In view of the
in view of the
duplicacy of
duplication of the patta.
Okay, so, against this cancellation,
Yes,
have you challenged?
I have challenged the repetition. It is in the petition.
Okay, what happened?
And a civil suit.
No, no,
The matter went to the High Court, and the High Court directed the plaintiff to file a civil suit and get appropriate relief. That is in the, yesterday I read it out, madam.
Okay.
And the page number 185, that is the order of the Deputy Commissioner for cancellation of the. Well, our main
Writ petition, where was the writ petition?
writ petition is not annexed. Madam.
Not annexed, sorry, order in the writ petition.
Order of the writ petition. Page 55, Your Lordship.
Okay, yes, this we have seen yesterday. And,
This is the order, madam. It starts from page 54.
so that was suspended for a time being, and in the meantime, you file suit. What is this? 185.
That earlier writ petition, page 59, in view of the above discussion, I have no alternative but to set aside the order dated 23/2/2004, passed by the learned assistant to DC, and direct the learned trial court to take up title suit number 2 of 2004 record and proceed to hear and dispose of the said suit on merit.
That was,
Page 59.
okay, order of the High Court.
Or, yes, order of the.
Okay, no, so, now 185 is issued This order has been issued in person to the cancellation.
This cancellation order we have challenged in the High Court, and the High Court directed us to file the
Okay, this
civil suit.
page 184 and 185,
Yes,
both.
yes.
Now, what about the issue number 14, 15? 11 and 13 are decided in affirmative.
Eleven and 13, this was against the plaintiff. With regard to the 11 and 13, the dependent appellant, as well as the state has stated in their pleading that they had the resettlement operation at the time, Dimapur Moza, and these settlement operation have been error and manipulation the revenue record, and therefore the partner number and right number have changed. Moreover, the plaintiff has not been able to controvert the contention of the defendant. The onus is always lies on the plaintiff to prove his or her case on merit.
You are
There-
reading at page?
Page 160.
Yes.
Therefore, issue number 11 and 13 decided in affirmative.
Now 14, whether patta number 71.
Pattern number 71, diag number, only block number 14, 15, and 19 taken up together.
Yes.
And these three issues issue number 15 therefore decided by holding that notwithstanding the difference of diag number and pattern number and the size of the land is the same plot of land being claimed by the plaintiff and the respondent. That is the page 161, first paragraph bottom.
It's the same plot of land.
Yes, the
Being claimed by
surveyor,
the applicant.
the surveyor who prepared the survey report is one T.P. Khatan, but he has not examined. examined. Therefore, the survey report is not true. The issue number 15 therefore decided by holding, notwithstanding difference of tag number and patta number and the size of the land, land is the same plot of land being claimed by the defendant number 3 and the plaintiff respondent number 1. The learned lower appellate court, because the survey report is very clear. Yesterday I have pointed out that there is a difference of the gap of 380 feet between the land of that A26 and D26. So Lordship has noted that. Therefore, as he is not examined, the survey report is simple. Notwithstanding the difference, the different like number, it is the same plot of land. This finding is wrong, my lord. Therefore, the survey report, it is stated that there is a gap between of 380 feet between the two lands. And that report was exhibited without any objection. Now at this stage, in the second appellate stage, whether your lordship can go into the legality and validity of that report.
Report was exhibited and proved by the officer himself.
The officer has not come, but it is proved by the plaintiff. No?
Three.
Sorry, PW3.
Okay.
There is a pillar from which the land was measured. My lord, yesterday I have given you this sheet, page number 186.
Yes.
Separate sheet.
Yes.
This
Verification report.
verification report. As per report of Larini, plot of land falls in tag number A26 under the physical possession and upon Ogni falls in AD26 of the area 1 kata 15 lashes of land. This gentleman, Pasul Naki, he was exempt.
So while deciding issue number 15, it says that it's the same plot of land being claimed by the appellant.
Yes.
Defendant number 3 and the plaintiff.
That finding is wrong. That finding is wrong because the verification report, page 186, I have stated, and he is examined as PW3 at page 117. And page number 118. This is the cross-examination by the state. The present land falls under block number A, Dimapur, Moza 2. The genuine map block number 9 in the office of the LRSO. It is a fact that the
That is where you are reading,
page 118. 117 is the deposition of
118.
117 is the deposition of the person who submitted the verification report, my lord. The land is two different land. Plaintiff land is another and the defendant, they are two distinct land. The plaintiff now want to get my land. My land because the reasoning is, I don't know, but what he has stated in his written statement, he want to install a stone crusher in that land. A stone crusher cannot be installed, as your lordship know, in a land measuring 1 kata 15 lashes. It is a big machine, my lord, and the boulders have to kept in another place. The finished product ships is to keep another place. Therefore, his statement or constructing this stone crusher is absolutely false.
So this 1 katha, how much land is this 1 katha measure in the meter
My
area? How much square meter it would be? The land claimed by you in the meter.
One lesser is equal to 144 square feet.
Square feet,
Yes.
144.
It is a
Around 50 square meter.
one lesser, no? 144.
144,
One lesser, no?
1.
One kata is 2,880 square feet.
Square feet.
And another 15, let's say, there will be another, say it is 4,000 square feet. Roughly.
One katha.
A kata is 2,200. 880. 15 acres.
3,000 square feet. And one lechas is
One less is 144 square feet. Mhm.
749. 749 square meter.
No, at page 171. At page 171, this is the name of the. Here it is for this. 216 less than equivalent to 749 square meter.
Page
171, doctrine of usefulness.
Where do we find? 749. 749 square meter.
Square meter. That is a column 5.
Column 5. Yes. Area.
That is the appellant's land.
749 square meter. It's not very big, though.
No, no, this is appellant. Appellant, it is 2 kata 16 acres. And the dependent land will be much less than 749.
So the decision of the lower appellate court on issue number 14. Is decided in whose favor?
Yes. 15 is decided, therefore
Yes.
decided, holding that notwithstanding the difference in
Yes. that
tag
is
number and
15.
pattern number size. It's
Where
the
do we-
same plot of land claimed by the appellant and the dependent.
Yes, where do we find the decision in 14? On 14. What is the decision on?
Yes, yes, I am coming. Mhm. Lordship, 14, 15 and 19
Okay.
taken together, page 160. And the conclusion is at page 161.
Yes.
This. There is no such specific finding on issue number 14.
Okay. No, 19 again below is therefore decided in the affirmative that the plaintiff and defendant are claiming title over the same plot of land.
Yes. And so far 17 and 18, these two issues are decided affirmative regarding the possession of the dependent number 3 over the plot of land. Over the plot of land. But these two findings are against the survey report that was exhibited without objection.
17,
17 and 18.
whether the defendant will take possession of the land. Seventeen, 18. Okay. What is 16? Whether the plaintiff right can plaintiff right can supersede the defendant number 3. title in the record of right if both the patra falls under the same suit length. 16 is decided. So according to the appellate code below, the issue has become infractious.
Yes.
So what is your submission here?
This is our case. The plaintiff says he got the plot of land in the year 1983. And the T. Murray got the land in the year 1960. Therefore, the dependent cannot get any title over the land purchased by the plaintiff appellant.
Now, your submission with regards to the issue number 16 is?
The plaintiff said can show yes, madam. Because my vendor purchased the land in the year 1960. And I purchased the land from vendor in the year 1983.
So it has not become infractious.
It cannot be.
Then issue number 17 and 18.
Whether dependent number 2 position. 18 and 19, my lord, I have, that is, these two issues are against the plaintiff. And it is not correct. Because in our evidence, we have stated that after purchase of the land, we got the possession, we erected houses. And the defendant does not give any independent witness.
How have you proved that you have erected houses and in under possession?
Well, in my evidence, I have stated, I have also exhibited some documents. Documents, yes. And my other witnesses, PW3 also, 2 and 3 also stated that I am in possession of the land. Page number 115, Your Lordship, see. Prior to the issuance of patta, 115. PW2. Prior to the possession of patta in favor of the present plaintiff, the office of the LRSO Dimapur conducted spot verification in respect of the present suit.
115 is the
Deposition of PW2 is T.S. Khita. It's start from page 112.
Yes.
He has stated that the he is close to the T. Muri, and he has stated in page 115, prior to the issuance of patta in the favor of the present plaintiff, the office of the LRSO Dimapur conducted spot verification in respect of the present suit land. And at the same time, I was conducted and inquired inquired from me regarding the original ownership allotted to the present suit land, to whom it was allotted by then Gauhati of Lankan Basti, and to which I told the official of LRSO Dimapur that the present suit land was originally allotted to Timuri by the then Gauhati Lankan Basti, namely let me out. And in my presence, I took the land Timuri and Gauhati Lankan Basti. I was personally known to both of them. The statement in the affidavit. In the cross, So far the issue number 21 regarding the relief claim. The other issues which are decided against the appellant, the appellate court gives the finding against the appellant.
I think 17, 18 decided against you.
Yes, ma'am.
There was a brick wall found present in the plot.
That brick wall is so far the survey report, the brick wall is constructed by the plaintiff. It was the report.
Brick wall.
Correct?
Survey work as per this, the survey report corroborates the testimony of the defendant. That in
In
1986.
survey report, my lord, it is stated that the brick wall is there only land measuring 2 × 16 lasers.
You never claim that you have constructed any brick wall.
In my plaint, that is not necessary. So we are challenging the order of the deputy commissioner, restraining order of the deputy commissioner.
And then you said that there was a thatched house. But this says otherwise. The survey report also does not speak of any thatched house with CGI roofing standing in the soil land.
But the learned lower appellate court, after taking consideration of all this, allowed the appeal. Against that, my lord, we prefer this appeal. My lord, where it is a judgment of reversal, your lordship is to look into the judgment of both the courts. Whether the trial court is rightly held or not. Your lordship has gone to the judgment of the trial court. Your lordship is to see whether it is a proper judgment of reversal or not. To look into that, your lordship is to see the I am very vital point issues I want to place before your lordship. So far, the issues that were decided against the plaintiff by the appellate court. So far, issue number 3, that is the schedule of the land, order 7 rule 3. Your lordship come to page 82. Decision number, page 82.
Yes.
That is the decision on issue number 123. 123, 123 is 3 is decided against us, against the plaintiff.
This is the decision of trial court.
Yes, the trial court held like this. At page 83. Upon considering the above submission, I find no infirmity in pleading dependent number 1 and 2 as the proper dependent in the present place. Dependent number 1 and 2. Further, in pleading of the legal heirs of T.L. Mori is not necessary in the instant case. And as there is no dispute between the plaintiff, the heirs of T.L. Mori, with regard to the non-description of the suit land, it is submitted by the learned counsel for the DW3 that nowhere in the plaintiff has given the description of the immovable property in contravention to the Order 7, Rule 3 of the CPC. However, I find force in the submission of the learned counsel of the plaintiff that the said provision is complied with the description of the suit land is sufficiently identified by the various records and the settlement of the survey and the measurement measurement of the area that was clearly mentioned and indicated in paragraph 12 of the plan and supported by the survey report updated 23/9/2002 and the Jamabandi dated 13/5/2003. It is well settled that the provision of Order 7 Rule 3 would be complied with where the plot of land is not identifiable by the plot number on the basis of the settlement and survey, that it is not all necessary in the plan to give the boundaries of the suit land. That is, the appellate court held it is necessary. And on the yesterday I submitted a decision of the Supreme Court Yesterday, I submitted one decision of the Supreme Court cases that copies you to your lordship. 2015-13 SCC 673.
Yes.
Paragraph number 11.
3. para 11.
para 11.
Yes.
Order 7, Rule 3 of the Code of Civil Procedure ensure where the subject matter of the property, will be specified in one. The object of the above provisions and the description of the property must be sufficiently identified. The property, the property can be identified by boundaries or by number in a public record is sufficient for survey. Even in the plate map showing the location of the disputed immovable property can be described. Since the present case, still the property has been described the plaintiff, the plate only for the boundaries, but the municipal number and giving the description of the plain map by no stretch of imagination can be said to say property it was not identifiable in the present case. And therefore, the Supreme Court held the Order 7, Rule 3 is not a mandatory. When the property can be identified on the pleading as well as the documents submitted by the parties. Issue number 4. The issue number 4 also decided against the appellant. Whether the document dated 23/11/83 annexure 1 of the plain, the probative value and consequently pursued the basis of the document. The trial court held it is in favor of the plaintiff. Yes. Ever issue number 5.
As we have seen, I think yesterday, issue number 5 decided in your favor.
It is in issue number 6 against us.
6 against you.
And the learned trial court
7 and 8 not interfered with.
6 is answered. The T.S. Katandik and T.S. Muri is supposedly elected in the election. As such, issue number 6 is decided accordingly. It is in our favor. Nine, 10, and 12. Nine, 10, 10, 12 also in favor of the plaintiff, my lord. It is at page 86.
Ten and 12, I think is negative.
At
Against
page
you.
86. These three are together interrelated, issue 9, 10, 12. For
10 and 12 decided against you, I think.
10 and 12 are answered in affirmative, and same was borne out of the record. Issue number 10 is answered by the government approval letter dated so and so exhibit P3.
Okay. So, at 2, then we may have to deal with substantial questions of law.
But the substantial, it will not much time, my lord. I have already submitted the facts and judgment. I now only want to say that the trial court judgment, whether it is bad in law, whether this judgment is actually liable to be reversed by the appellate court. That point I can show. Thereafter, the substantial question of law framed by this court, it is actually not very substantial question. Your lordship can formulate it. Because I have seen that some are not necessary to decide. Because 2 or 3 substantial question of law is enough. Here are 11 substantial question of law. Maybe your lordship is to modify it.
Division bench, single bench, no single bench.
Division bench. More division bench. Yes, all the ball. In which statement? It's some. Page one. What examination? Yes, confirmed. Now it's shown the same executed as V1 are correct. This boundary is plaintiff's present boundary is possible.
Twenty that,
Yeah. You were completely ignored by perfect.
The knowledge is
It's bound. In this one, from the person.
the boundary is shown.
In the same thing, exhibit P1. So this boundary is just for the same thing.
B1 is
Even though. Inside. Yes, that's what it is. So we decoding all these. Hours in all the note. Yes, yes, sir, that's what we report. Plain to web not show the boundary, na? Salient right? Salient is the X. This is the same page 30. This is not outside. Here it is east. Even if you are very important, the same boundaries. Hours and survey report.
what's that report matching to our boundary, but their boundary.
First time. Crazy report, yes. Then you will understand.
Even in the trial court judgment. This has been.
Yes, sir. Trial court judgment. Well, I am reading the trial court judgment.
Yes, that will be better.
Trial court judgment, my lord, the issue number 3, that was decided in favor of the plaintiff, which was appellate court reversed. My lord, the trial court because in reading the it is a very long judgment.
Yes.
Some important point I just want to
Yes.
point out. Issue number 14, 15, and 19. It is page 88.
Yes.
These three issues are decided in favor of the plaintiff by the trial court and reversed by the appellate court. The issue number, validity patta number 71, like number 172, block line and patta 10. Should then measurement. Issue number 15 is this. The above three issues are the cards of the contention between the plaintiff and the three in the instance. The pattern number 11, like number 10. Okay, so 71, like number 172, block 9, measuring an area of 1 katha 15 less as in issue number D, issued to D3, whereas pattern number 1009, like number so and so, Dimapur block measuring Iman, 2 katha 16 issued to issued to plaintiff. Your Lordship, see the boundaries of two land. Land of D3, north, land of Chungiro Lotha, south, land of Ingmong Jamir, east Dipurot, west Patta land. And land land of the plaintiff, north roadside, south Lotha, east Kondo Lotha, and land of Ayao. Therefore, the two land of the plaintiff and the land of the dependent tree, is quite distinct and different. Page 89 of Lordship kindly see. The land of D3, that is the respondent in the defendant, and land of the plaintiff. To different, different, and this will prove the this will prove the if your lordship turn to page 119. That is the position of dependent tree.
Dependent tree.
Yes. Dependent tree in Mysore. Examination chief of the dependent number 3 as DW1 under so and so. I, Apong Pongir, as it about so and so. I am the dependent number 3 in the above suit in the instead matter in relation to the enforcement of the case measuring 1 kata 15 lessons of patta number 70, dag number 172, situated block 9. Bounded by on the east Difu Road. Your lordship kindly note it. On the east Difu Road. On the west Pattaland. On the north land of Chungirao Lotha. And on the west, on the south, land of Imkom Jabir.
Same.
But it is not same.
It's not same.
Not same. Page 89, your lordship, see, only not. Huh? Same. And my lord, it is same. And then your lordship.
No, this page 89 and 119. The lane of the D3.
On the east,
D3.
Difu Road.
East is Dipu Road, same.
Same.
West is Pattaland, same. North lane of Chungira Lotha.
Yes, it is same. And south also same, my lord.
South also same.
The boundary. Thereafter, your lordship see in his cross-examination at page 124. Line about
1, 2.
Page 124. Line about 15. Line 15 from the
124.
page 124. line number 15 from the top.
Yes.
The cell, the boundaries shown in the cell deed exhibit D1 are correct. Then your lordship see page 49.
Page 49.
Page 49. This is the boundaries of his cell deed.
Yes. It is also same.
Same matter.
East.
Is the road, Pataland, land of Sangyu Lotha, and now. And the page 34 of his written statement. It is same. And therefore, then your lordship then again come to page 89. That is the finding of issue number 14, 15, and 19. Page 89. Land given by the defendant number 3 is same as per cell deed, deposit, etc. But the boundary given of the plaintiff is different. The land of the plaintiff bounded by North Rothside and the defendant North Sangyu Lotha. South M. Lotha. Here south Imkong Jamir. East Sri K. Lotha. Here Tifu Road. West Pataland. Here Imkong Au. Therefore, from his from the deposition of the plaintiff and the findings of the court is this, that the two lands are different land.
Okay. So this is, so where is the, let us see, map and the report also about the land of the plaintiff. Is it the same?
Yes. 1-3, yes. Page 13, 1-3.
Roadside,
Roadside.
Mabemo. Gombao.
And the next page,
Hmm.
on the next page, it is a survey report. Boundaries are same.
Page.
Next page. Page 14.
Yes, same.
Next page is the trace map.
Hmm.
Here also the boundaries are same.
So this map is prepared by LRSO.
Yes.
Survey of the
Hmm.
the second survey report is page 187.
One.
187.
As per order of census spot verification had been done by RO, ESE, Revenue, LRSO, and, and self along with both parties. According to Revenue Record Trace Map, DAG number A26 and area 2 kata 16 lessas, 16 lessa belong to Larini. And DAG number D26.
In the second survey report,
Second survey.
the description given.
No, here it is stated that the DAG number A26.
DAG number. Okay, A26.
A26, 2 kata 16 lessas belong to Larini, and D26, 1 kata 15 lessa belong to Apong, as per trace map of 71, is 380 feet away from the Larini's allotment and the trace map. The allotment which belong to Apong Ponginar falls under DAG number 16D, area 26D, area 1 kata 15 acres, which is presently occupied by W. Zamir. As per-
380 feet means it's about more than 100 meter away.
Yes,
100 meter distance
distance,
between these two lanes.
two lane,
The lane of the plaintiff is dark number 26, A26.
A26.
And the lane of dark number D26.
D26, 1 kata 50 lesa.
Okay.
And the next page, the map is there,
189.
189, 188.
Sorry, 188.
On the top, it is written as A26,
Okay. A26.
A26. And on the other side, from bottom, A, B, C, D.
Yes.
On the bottom, A, B, C, D.
So this was prepared by LRSO.
And from bottom, A, B, C, D is the land of the dependent number 3. Therefore, the
So this was prepared by Kitan. Whether this person who prepared this survey report, LRSO, is this the one who was examined?
Kitan was examined. Madam.
Oh, he was examined.
Huh?
So has this been?
No, but the officer who was in charge of the LRS office, he was examined. The PW3.
Okay, the person who prepared this was not examined, but the LRSO was examined.
Yes.
This is surveyor.
He is surveyor,
Okay, the surveyor was not examined.
was not examined.
Okay,
But the
but
officer,
whether this LRSO, the officer, whether he exhibited, this map was exhibited.
yes, the statement, the report was submitted by the LRSO to the deputy commissioner at page 186. He was examined.
No, this trace map of block number 9, whether he has this been exhibited, showing A3, so A26 and D26.
But this was exhibited.
Exhibited.
Lordship, may kindly see the exhibit at page 9. The trial court has given all the exhibits at page 98. Verification report submitted by P3 that has been exhibited. PW3.
Page 98, exhibit number?
Serial number 17.
17 is the
P17.
verification report that is prepared by PW3. That has been exhibited. Survey report and the trace map is not there.
Okay. Survey report is not been exhibited. So is this the part of the document?
This is part of the exhibit.
But you did not exhibit.
No.
whether Mr. Wabang Jamir was examined,
No.
who is stated to have been out in
That
occupation
is,
of
that
land
is,
belong to the.
that is dependent.
No, as per the report, the Wabang Jamir was under the occupation.
Wagon Jamir, he is occupying the land of the defendant.
Defendant.
It is their duty to examine him.
No, they did not say that it is under the occupation of Wabang Jamir. It is the officer and you who is saying it is under the occupation of Wabang Jamir.
We have not examined.
Not examined. Because it is to be confirmed that Wabang Jamir, what the lane occupied by the Wabang Jamir was belongs to the defendant or not.
It is as per the.
Because in all the documents,
As per the
say-
report of the officer.
report, and in your allegation also, it is under his occupation, Wabang Jamir. The lane of the defendant is under the occupation of Wabang Jamir. But then Wabang Jamir has not been examined. Then how would we know that there was a person named called Wabang Jamir who is under the occupation of the lane, according to you, belongs to the defendant?
Basing on this report, basing on the
No,
report.
that is why in the report it says Wabang Jamir by the officer.
This is in order to show that the land of the defendant number 3 is not the land of the plaintiff.
Because they are claiming your lane.
Yes.
But you are saying that he has different lane in a different location being occupied by Wabang Jamir. Now, who is to produce this Wabang Jamir?
Wagon Jamir is, his name is mentioned in the report.
Yes.
But our case is this, that we are the owner of 2 kata of 16 acres of
Yes,
land.
yes.
And our land is, as per his deposition, the boundaries are entirely different. His deposition, as I have already read, these two lands are different. Therefore, the learned lower appellate court is hard in holding that the land is same land.
They are also saying the same land.
They are occupying my land, they will say, but their deposition, the boundaries I have already pointed out. This is different boundaries. Boundaries are different means there are 2 plots.
During, after this 186, 187 survey report, second survey report, is there any occasion or anybody, any person, officer, or from the court, or from the direction of the court, any person visited the place?
No.
There are no report, nothing.
There's no survey commission. No support.
So the person have prepared their own map, the plaintiff and the defendant.
Excellent. Excellent.
Okay. Yes. Or whether any of the, because you are showing that your land are bounded by these people at page 13, 114, 13, 14, 187. So whether say your neighbor Mavemo Lothar, Konda Lothar, Kong Lemba Au, whether any of them were examined?
No.
No, okay. They did not say that we are bounded by, we are neighbor. None of them has said anything.
No, they have, we have not examined them.
Okay. So now we do not know whether there is a person named Mavendra Lotha, Kondam Lotha or not.
We know our boundary man. We mentioned, but we have not examined.
Okay, whether the defendant has examined the Chumriya, Chungira Lotha,
No.
Imkom Jamir also.
No.
Defendant also not examined.
Hmm.
Then I think it will be a little difficult. Both have not produced any material witnesses who could prove. At least one of them could also have been produced to say that, yes, he is my neighbor. At least one. But all could have been produced, but then at least one, not even a single material witness has been examined. Not that Jamir, none of these. And now you see, it's like a hypothetical claim by both the parties. We do not know now whether the land really exists or not.
That is right, my lord. Both of the parties have not examined. Either.
PW2.
Yes.
Who supposed to be the friend of the original.
And the surveyor also, the surveyor was not examined. The officer who did not visit the place was examined.
Because he retired by that time.
So it was found a little difficult. Yes, PW2 of PW2 page.
Page 112.
Yes.
ISHG Kithan, the permanent.
Kithan is the officer.
No. Okay. He was a friend of this T. Muri.
Okay,
Yes.
but then
He is a neighbor of this. No. He is resides opposite to that land. Suit land.
Okay, but he is not connected with the suit land.
Not connected.
Neighbor.
No. He is that opposite to the suit land.
He is a friend of More.
Yes.
Yes. What do you want to show from this? From his
evidence.
Affidavit in evidence.
Paragraph number 3. 113. In year 1960, I came down to Dimapur and stayed at my friend's place for about 2 to 3 years, 2 to 3 months. And thereafter, I occupied the present plot of land and settled therein permanently till then. Late Timuri is the elder brother of Srimati Lirini Kinon, who is the plaintiff in the instant suit and the intimate friend, and we hail from the same village, Iphum village. Late Timuri also joined in the Naga National Council in the early part of 1956, and he was appointed as the post of Kilosner, and subsequently he was relinquished the post of Ang in 1958. He succeeded my post of Ang in the early 1959. Timuri was arrested by Indian Army in 1959, and he was released from the custody of the Indian Army in the 1960. Thereafter, in 1961, Timuri came down to Dimapur and met me, and he is willing to settle at Dimapur, but at that time, he expressed that he has no plot of land at Dimapur. As such, I took him to the house of late Aim Au then the then Gauhati of Lankan Basti and requested him to allot a plot of land of my friend late Timuri, and he was the sole authority to allotment of the land within the jurisdiction of Lankan Basti at the relevant point of time. And let Ayum how the then Gauhati of Lankan Basti allotted the present Sutland to T. Muri in the year 1961. Opposite to my present plot of land, the residents were so as to enable the Timuri stay the adjacent to each other with me. Here, my lord, he said that the Timuri is on the adjacent land. 1970. Timuri was the original allotee and constructed the Techet House in 1961. Itself and they are constructed by late Timuri become dilapidated, and I was requested late Timuri to replace with a new thatched house in the Sutland. As such, I am engaged some laborer and constructed a new thatched house and they rented out to some tenants. Therefore, the present Sutland in the present suit was originally allotted to late Timuri in the 1961 by the then Gambura of Dankan Basti, namely I am Au, who married a Lotha lady from Lacho village. Late Timuri contested the Nagaland general election twice in the year 1970, but unfortunately he failed to get elected, and thereby he became the bankrupted. And for this reason, he disposed of the present Sutland, who his youngest sister, Tarini Kikan, and the present plaintiff in the year 1983. The Sutland was allotted to late Timuri. Entire Denkan Basti was non-cadastral. The present Denkan Basti was established by few lotas and houses in the year 1950. And the Pata system was in respect was introduced only in the year 1968 when Mr. R. N.G. was the serving AC1. Prior to the issuance of the Patta in favor of the plaintiff, the office of the LRSO, Dimapur, conducted the spot verification in respect of the present Sutland. At the same time, I was conducted and inquired from regarding the original owner allotted the present Sutland, to whom it was allotted to by the then Governor of Lankan State. To which I told the officials of LRSO Dimapur that present Sutland is originally allotted to late Timuri by the then Governor of Lankan State, namely I am Au in the year 1961. In my presence, I took later Timuri, then the Gauhati of Lankan Basti, and I was personally known both Gauhati, Lankan Basti as well as Timuri. The statement in the paper to my knowledge. And the deposition, cross-examination, my name is, my full name is this, my age 83 years. I migrated to Dimapur in the year 1960. I say that in the year 1961, I took my friend Timuri to the house of then Gambura. I am requested to allot a plot of land. During the relevant period, Gambura, the sole village, worked the authority to allocate the land to the various individuals. I say that the settlement operation introduced in 1960 year. All the Gamburas the similar right and power to allot district land. At the time of allotment, no written document was executed. The University was established in the year 1950. Timuri was a childhood friend of my village who happened to my brother-in-law. I denied the suggestion, and the plaintiff and the brother of Timuri related to me. The post. There is no suggestion that there was no allotment by the Congress, that it is not a false, you have made a false statement, there is nothing. Only I denied the suggestion since the present plaintiff and brother Timuri is related to me. Only this. Melody PW3 is submitted the verification report.
He is not the one who conducted survey.
Yes. Kitan.
Yes. Come. Because he did not visit the place, the spot. And then if it was if it was this map was submitted by him, would have then exhibited this 188 also. 188 did not exhibit. This is
His deposition is this. I prepared the.
because as per your submission, this appears to be correct.
Yes.
Appears to be correct, but then it is not authenticated again. Proposal map. It is 1971 proposal map. It is say proposal map. So it appears that this is only proposal. If this has been, had this been authenticated and if this was exhibited, then it appears that what you submit seems to be correct. Because you say that there is the lane of the plaintiff and the defendant are different locations at the distance of about 100 meters, little more than 100 meters. And this clearly, of course, shows, but then this was not exhibited.
But even though he is not examined, but there is no suggestion that he give the evidence falsely. The present land falls in block 1, but it is genuine map block 9.
Yes. Or anything else?
Therefore, the trial court judgment is a correct judgment, my lord.
Now, that is about the fact. Then what is the wrong decision of the appellate or appellate court? And now, can we come to the substantial question of law?
Yes.
This is the second appeal, that is where fact, of course, not the entire, but in fact, now we come to know little about the fact, but then now let us see what is the fact.
These are the substantial question of law framed by this court on 19/6/2020.
Yes.
These are the whether the lower appellate court are in law in interpreting Order 7 Rule 3. It is a substantial question of law. Because I have the law is the Order 7 Rule 3. Description is required to be given. But the ruling I have submitted that it is not a mandatory. Therefore, if from the other documents I can prove that this is the land, then the boundary is not necessary.
So this,
Now the other substantial question of law, number 2, whether the lower appellate court are in holding that the cell deed number so and so has not been proved by the plaintiff, and it was held that the cell deed is admissible in evidence. However, the learned lower appellate court are in law in holding that the document has not been proved and the same has been exhibited without objection. So far this too is concerned by the cell deed dated 23/11/1983 that was exhibited without any objection.
this is your cell deed.
Yes, madam.
It was not proved.
It was not proved.
So there must be some, let me just see once where the cell deed. Cell deed is at page
1-3.
So this, the witness, E. Limatho and Moncho was also not examined.
Not That's, yeah, I like it.
At the time of filing suit, the P. Murray was no more.
No more. Remember the issue number, substantial question number 3. Whether the learned law appellate court are in law in accepting the contention and statement made by the pro forma dependent in their written statement. Though no evidence was laid by the state defendant to prove their case. Well, this is the, no.
Whether the written statement was accepted.
Yes.
Appreciated. Based on the written statement filed by the state, the some issues were decided. Or what? Not decided.
But I have a decision.
It was not taken into account.
Because there's a that these are the statements, written statements, but the issue was this, the suit was decided
decided.
on the basis of evidence only.
Okay, not based on that.
No, not based on that.
Okay.
No, the evidence given, the statement given by the state without recording, without giving any evidence. The Supreme Court held that the statement made by the defaulting party is false and incorrect.
Okay. So, but then it was, the suit was also not decided based on the written statement filed by the state.
But they have highly written statement supporting the case of the defendant.
Okay. Deciding which issue?
Issue
In
by
deciding,
all these, some issues which are
But
related to this.
the written statement of the state has not been referred or taken into account. Has it been taken into account for decision of any of the issues?
Then your lordship can see the written statement filed by the
Okay, but
defendant.
written statement there, of course, but then whether in the
Findings.
judgment,
Yes.
whether while passing the judgment, the learned court below has based for decision of any of the issues, the written statement.
Yes.
Basing on the written statement filed
Yes.
by the pro forma, any issues have been decided.
That I will submit my letter.
Okay. Otherwise, this seems, it was not based on, this seems, this question. Substantial question probably may not be required to dealt with.
Yes, yes. Whether it is number 4, whether the Learned Law Appellate Court erred in law in holding that the Dimapur cadastral map as a creation of Duncan Basti, as alleged, is not in accordance with law. That is also not a question of law, madam.
Yes, this,
Whether the Naga customary law,
this was not discussed
Not
in the
discussed,
judgment.
not urged.
Hmm.
Naga customary law, different claims prevailing right. That
It
is
was
also
not decided as part of the customary law.
So we will have issue letters.
But I am sorry, page number 159. 159.
One 159.
159, second paragraph.
Hmm.
The state defendant have stated in the written statement that there is
159,
159,
second paragraph.
second paragraph,
Okay.
from 7 line. The state government,
No, second paragraph.
second paragraph, line 7 from the top.
The state defendant.
Stated in the written statement that there is no record to show that the plaintiff applied for regularization of patta of dispute land in Highland prior to 2002. On being cross-examined, it stated that she cannot collect the deed. When did she had applied? The written statement of the defendant was taken into account by the court.
No, so.
You can to the written statement of performer defendant number defendant 1 in the written statement page 65.
Page
65. That with regard to the statement made in paragraph number 9 of the plaint,
Just a minute.
the defendant begs to state that the Patta system was introduced in Dimapur area, including the para 8, including Duncan Basti prior to 1961. It may further be stated that the resettlement operation of Dimapur area during 1968-69, entire area of Dimapur, including the Duncan Basti, was brought under the cadastral area. There is no record to show that the plaintiff applied for regularization by Patta of discipline. The statement made in paragraph so of the plain matters of record. The statement made in paragraph number 14 and 15. It may be stated that the defendant number 3 has filed a complaint before the defendant number 2 against the plaintiff for illegal enforcement and unauthorized construction over this land. Therefore, the pro forma defendant number 2 directed LRSO to conduct detailed survey report and submit a report. In the meantime, both the parties were restrained from the development. The substantial question number law 6, whether the landlord appellate court are in law holding that the creation of Duncan Basti is not relevant for the disposal of the appeal. It is relevant because the Duncan Basti was created. And the land was settled by the
4 and
government.
5 is not required to be dealt with. Substantial question of law.
4 and 5 not required.
How it is relevant?
Because the Duncan Basti, the Gauhati has allotted the land. Therefore, the creation of Duncan Basti is necessary.
Is this question exactly?
Question mark.
What this question is actually? 6.
My lord, actually the case lies on the identity of the land. I say I am the owner of 2 kata. I was allotted land, became the owner of 2 kata 16 acres of land. And the defendant claim that he is the owner of 1 kata 15 acres of land by registered children. Only dispute between the two parties is this, that whether this is the land or both are land the same, or it is a quite distinct land. That is the main point, my lord.
Yes.
My lord, here I may suggest your lordship to appoint a commission by this court to see whether the A26 land is under occupation of the plaintiff and D26 under occupation of the defendant. If your lordship get a opinion from the state government that yes, this is the actual position, then the entire matters will end, my lord.
Right.
And the High Court has the power under Order 26, the issue of commission. That may also do instead of fighting. Because I am in possession of the land. And the defendant in his written statement given boundaries, the boundaries are different. His deposition boundary and the sale deed boundaries are different. Therefore, where is actually his land and where is my allotted land? If it is, as your lordship issued a commission, then entire matter will solve and both parties can live peacefully. And another thing is this.
Yes.
Another thing is this. But I filed a suit for the cancellation of the restraining order. And they have challenged this, my lord. And my whole case is this, I am in occupation of 2 kata 16 acres of land.
Yeah.
And there is no counterclaim from them that I am occupying his land and recovery of that possession. Suppose my suit is dismissed, my appeal is dismissed, even though the material dispute will remain.
Because your claim is that there is 2 distinct land. But in fact, it appears that there is no 2 distinct land.
Okay.
Your claim, you said according to you, there is 2 distinct lands.
2 distinct land.
A26 and D26.
Yes.
But in fact, it appears from the lower court appeal judgment that there is only one plot. Both are claiming. One claiming that to be the same plot of land to be D26 and the other claiming it to be the A26.
But the survey report is a government officials report, that is, they're not prepared. Is not prepared.
The person who visited, who conducted survey was not examined.
Yes, no.
And then you are claiming that you are bounded by these people, not examined. And they are also claiming that they are bounded by these people, not examined.
Not examined. And the boundary is given by them also different.
And it appears that boundary different location, because probably it is also possible because he has covered a smaller lake, will have different boundaries. You are claiming bigger land, you will have a different boundary. That is possible, but then within your lake, it appears he is claiming.
I have a wall.
Hmm.
Fence though.
Yes. So what the Learned Council for the appellate?
Lordship, I understood commission,
Yes.
regarding the commission. Lordship, it is not possible in second appeal. In second appeal, the law is settled, my lord, that only the question of law formulated, that has to be decided. Only this hearing should take place only on the questions of law formulated. And then, and this issue that I need a commission, they never ask for a commission in the trial court, nor in the appellate court. Can I do it now? And Lordship also, I show when my turn comes that absolutely this is the land. Some reference, Lordship, I'll also make the picture clearer. Some, Lordship, incorrect. I don't want to say that, maybe.
Okay.
Yeah, so this is bulky, so everything, but I handled in the appellate court. So I am conversant with the materials, pleadings, evidence, documentary, as well as the possession given and the findings of the trial court. But since we are in second appeal, we have to go, and this questions of law formulated, my lord, and accepted by the High Court. This was
on the basis of this question of law.
yes. This was yes, Lordship. This case when the motion itself, the case was admitted, and the questions of law, which the court has framed, is verbatim what they have submitted in the memorandum of appeal. What they have given, court has submitted without hearing us, and so this has to be heard, and it will be decided on that only. It can only be decided on this, because that is the law. We here
Not possible under Order 26.
Order 26 right now, no. That's my at this stage now.
So the commission.
And Lordship.
My lord, in
second
that
appeal,
case,
at the stage, second appeal.
my lord, in that case, the appeal is a continuation of suit.
Yes, it's a continuation.
So it is if it is a continuation, then we will make a prayer.
Appeal is a continuation of suit, but this is second appeal.
If second appeal is also a continuation of suit.
Hmm.
First appeal, second appeal is a continuation of suit. Then in that case, my lord, so far I am concerned, the only dispute regarding the boundaries of the land. And therefore, if your lordship adjourn the case today, then we will file an application. Your lordship will hear the matter.
Lordship has heard this for 2 days. They have almost concluded, Lordship. Kindly hear me also.
File,
Yes.
file what?
For issuance of commission to find out the exact location of the plaintiff and the defendant. If that is come, that is the matter is disposed of. Because if my appeal is dismissed, even then they cannot get any relief. Because they have no counterclaim for recovery of possession. Because entire land is on my possession.
They have illegally encroached upon the land, and then because of a stay order here on this in this case, they injured.
And says that you have made no counterclaim.
Of course, no counterclaim, Lordship, but
Then in that case, even if it is decided also, will it be possible?
Lordship will take whatever steps has to be taken, but let this appeal be decided. Let this title be decided. And this is a question of title. I'm saying that they are illegal occupants. But
Now,
steps
on
needs to be
fact-
taken.
On fact, the suit was decided in their favor.
Suit was decided in their favor.
Yes.
It was wrongly decided in their favor. Lordship,
But you see, unless your case also, they failed to show the dispute.
no, Lordship, my case.
But then in your case also.
No, Lordship, that's why I want to show that I have not failed to show They're saying that I've not examined those persons who are my neighbors. But that is immaterial from what I'm saying, because the document itself shows. Lordship, there's one question here. The document itself, the basis of the claim is in the survey report, 2002 survey report. That itself shows the land is vacant. Wrong statement has been made that after the purchase, from the evidence, Lordship, after the purchase in 83, thatch houses were constructed. It was rented out. After it came to the plaintiff's hand, she had constructed thatch houses. Even before they had constructed, even the PW2 says he also was entrusted to construct houses there. And the plaintiff herself says after she purchased it, she constructed houses. And then it was rented out also. Lordship, there's no evidence as to that effect. In fact, the survey report of 2002, based on which she made an allotment, she sought for an allotment of the land, says that it's bounded by a brick wall and the land is vacant. Lordship, that is one. There's not even a whisper in the pleadings, not even a whisper in the evidence that she constructed the wall or her predecessor in interest constructed the wall. All along in my pleadings, in my evidence, I've said I've constructed the wall in 86. Their document itself supports my case. The basis of the claim, the document which they exhibited as one of the exhibit, that itself supports my claim. And Lordship, one more question, that the story is concluded. If she had purchased it, why ask for allotment of the land? What is allotment? Settlement by the government. The government is the owner, and government makes the allotment. When I purchase it, I don't ask the government for allotment of the land. I ask for transferring the land in my name, mutation.
Yeah, here in the same case, he was not given allotment, although allotment was given by the Gambura.
Allotment, of course,
But
very
it has to be allotted
very
by-
convenient to say allotment can be given by was given by the Gambura. Can the Gambura have given allotment? It was not, Dimapur was not under NEFA as submitted. Dimapur was a part of the Naga Hills, which was part of Assam. Assam land revenue regulation was applicable. Her own witnesses says that from 1968, Pata system was enforced in that area. Her own witnesses, Lordship, I'll take your Lordship through all this. So what? 68, where was she? What was the land? It was surveyed, made a cadastral land, and Pata system was introduced in 1968. Her PW2 says that.
Friend of Murray.
Her part of the pleadings also. Then why? Her occupation is 2003. Her own statement says that. Her own evidence says that. I also say in 2003 only, I have built the brick wall. I stay in Mokchung, Chunky village. Somebody told me that somebody has encroached the land. I came, found, inquired, who is this? Then I found out that an allotment has been issued, given to her. But a government allotment. It's not government land. How could it have been allotted? And on that basis, Jamampati has been prepared. On that basis, she entered my land and she constructed a thatch house. And then, no, we failed to evict her. The cancellation order was given. She continued to remain. She came to the high, she filed a suit. At that point of time, the suit was filed before the assistant to DC because judiciary and executive was not bifurcated. Assistant to DC, judicial. And Lordship, everything is there, Lordship. In fact, Lordship, what I intend to do when my part comes, I prepared a written argument also, detailed written argument, page numbers, everything mentioned. After that, Lordship, I will also rebut, or I also will reply or deal with the argument made by my learned senior colleague.
So, what do we do? What, you probably have to continue or what?
Yes.
Well, my argument is already
Okay, completed.
complete. Because the learned lower appellate court
Hmm.
is not correct in reversing the finding of the trial court. The plaintiff has filed the suit because she got the allotment. She got the allotment from the government. Your lordship kindly look to plaint. It is not that she is plaintiff is forcefully occupying land. Paragraph number page 16 of the plaint, that it is additional paper. Additional paper. It is absolutely pertinent to state that T. Muri was serving as an arm in Naga freedom movement set up in the year 1950. But he was arrested in the Indian Army in 1959. And only in 1960 he was released from the custody of the Indian Army. As such, after he was released from the custody of Indian Army, T. Muri came down to Dimapur and requested the then governor Duncan Basti, namely, I am Au. The above governor was kind enough to allot the plot of land measuring 53 into 1 feet in the year 1961. Thus, the above mentioned original allottee, namely T. Muri, constructed a thatched house on the land allotted in the year 1961 and resided same in the house for few years. But due to illness, late T. Muri could not stay for long. As such, on the health ground, T. Muri shifted to the Okha and resided Okha town. However, rented out the thatched house to other person. After his thatched house became dilapidated and entrusted to friendly T. Kitan, who is residing near the plot and construct new thatched house on the plot. Accordingly, T. Kitan constructed house to it. After construction, 3 times allotted the tenant T. Muri not reconstructed as due to financial problem. The original allottee of the said land was the sister and the present plaintiff instead of considering rupees 60,000 for sale deed. It is pertinent to mention that the plot of land was taken possession by the plaintiff peacefully and without any disturbance from any quarter. That having purchased the land, the original owner, the the plaintiff moved for the regularization of patta from the competent authority as per land purchase from the plaintiff originally allotted the aforesaid Gambura of Dankan Basti, India, 1961. Then there is no patta system was introduced at the relevant point of time. But the passage of time, the present place of land became the new cadastral area. And the plaintiff applied for patta due to the signs of the officials and due to inadvertence on the part of some officials of the Land Revenue Branch, the office of the ADC Dimapur are displaced by the present plaintiff. And therefore, the plaintiff once again pursued the process of issuance of patta of the land purchased by her. And at the long last, the land was surveyed by the competent authority and the surveyor verified the spot and the plaintiff as well as the neighbors. Thereafter, the survey report was submitted by the competent authority. The land survey was forwarded to the government for approval of issuance of patta Deputy Commissioner Dimapur dated so and so. According to the competent authority, approved the proposal of the patta in favor of the plaintiff. It is important, brother. Accordingly, the competent authority approve the proposal for issuance of patta in favor of the plaintiff in respect of the said land by the government approval letter so and so. In pursuance to the approval of the government as stated above, in respect of the suit land, the defendant number issued a formal settlement order dated 5/2003 in favor of the plaintiff with certain terms and conditions. After the settlement of the said settlement,
Read earlier, I think.
my lord,
Okay.
after the settlement of the said issue, the plaintiff paid the premium of rupees 1,866 in the form of treasury salan that is so and so. So the said land. Therefore, the Jamabandi was issued in favor of the plaintiff. Filed letter, filed so and so, bearing number 1009, lag number 1134, block 9. The plaintiff paid the yearly land revenue, as per the house tax. She paid also house tax. There is a house. The filed receipt number shows against the 387 of Lancaster Mustino constructed the plaintiff. It may be stated that the said house constructed by the plaintiff was ordinary CGI. The land revenue paid receipts, house tax receipts are annexed here with 7 and 8. There is a house constructed by the plaintiff. After having issued the patta,
Plaintiff allotment is 2003.
Yes.
3.
And then the defendant is in the year
85.
85.
85. 86 Jamawan.
Okay.
After having issued the patta by the competent authority in respect of the said land, constructed CGI sheet roofing of plaintiff took physical possession of the land without any interference of any corner. But surprisingly, plaintiff received the impugned restraining order dated so and so on the ground that the defendant number 1 came to the notice due to the allotment in favor of the different individuals. The above said impugned order and the complaint was received by the defendant number 3 claiming the land, further directed the LRSO to go through the revenue record available in the detailed survey report, and the impugned order further stated that in view of the dual allotment of the same plot of land of the parties to establish their structures where they created unwarranted situation, and therefore the both parties have been restrained from. Therefore, my lord, I am not forcefully occupying or illegally occupying the land. There is a settlement order passed by the government, and on the basis of the settlement order, I am occupying the lands. I raise the house, paying house tax, land revenue, everything. It is not the case that the plaintiff forcefully occupying the land, vacant land.
Whether in the judgment, survey report was not accepted.
Competent
In the
review.
substantial question of law 8.
Yes, my lord.
It
That
was
is-
not accepted.
2005 survey report, Lordship.
Hmm?
2005 survey report, which is not an exhibit, which has not been proved.
Whether the Ladakh Law Appellate Court ought to appoint survey commissioner to find out the position, occupation of the parties in respect of the suit. This is my this is my prayer before your lordship to appoint a survey commission to find out who is in possession and the basis of their possession over the land.
Did you make prayer before the lower appellate court or trial court? No. No prayer was made.
No prayers.
Then the appellate authority appoint unless there is any prayer for such appointment. Unless the prayer is made, can the appellate authority appoint?
The court has the power.
But then nobody is pointed out. Nobody has pointed out and made a prayer for appointment, such appointment.
Of course, madam, no application was made.
In the instant case where the trial court has already decided, it was in the appeal.
And that, of course, no, but the court has the power to issue a commission.
So according to you, the survey commission could have been appointed by the appellate.
By the second appeal also it can be appointed. There is no but because it is a continuation of suit. If the court is to come into definite conclusion, then where is the bar?
You may have to file application and satisfy the court for that.
No, we will file application to that effect.
You have to satisfy the court. Because in the second appeal also, this court has a power.
Yes, second appeal it is. Because in the other case, the court so moto issued that case was also conducted by me.
In what case?
Yes. First appeal 1 of 2009.
First appeal. But this is second appeal where we are dealing with a substantial question of law.
First appeal. Can I see?
Melody will make an application. The whole problem will be solved because
it appears, but then whether this
because they have not filed any counter claim. If I am in possession of the land, they cannot evict me.
now, in the meantime, the hearing will continue, but in the meantime, if you can make and satisfy the court.
Lordship, if I may, Lordship. They have submitted today, yesterday, everything. Now they're having some obstacles and therefore this is coming up. Lordship, they are the plaintiff. They are the plaintiff. The law is settled. The law is settled that the plaintiff must establish their case on their own strength. Just because I have not examined some witnesses, they cannot rely on my witnesses, if any, to support or succeed. They have to establish on their own case. They have come with a specific pleading, and on that basis, on the basis of their pleadings and evidence, they must establish their case. They cannot ask the court just to favor them for a commission at this stage, particularly when the Supreme Court, Honorable Supreme Court, clearly says only issues urged before the trial court and the appellate court can be taken up. When that has not been done, can they make this prayer now? then they might despair.
Okay, and 11 also the same question comes up.
Same question. But, the question of me not filing a contract claim that whether they will not be ejected from there. Lordship, that is not the lookout. That is my problem.
So, what?
Well, I am concluding my argument. And I shall give a reply after hearing them.
Okay. So state also probably need to submit.
Yes, I'm a professional respondent, I'll just submit shortly on the.
Okay. Will it be hard?
Today, your lordship is impossible to conclude and to break, submit and break again. The lordship is inconvenient for your lordship also. So if I may suggest that we continue on Thursday.
In that case, our lordship, I can submit today my part. So that I may be excused on Thursday, your lordship.
I have no problem. I have no problem. It's up to the court. But I'm responding number one in this. What
So
in the
let the respondent number one submit
Our
first.
lordship.
So, so on Thursday.
Lordship.
Tomorrow,
Tomorrow is Wednesday. We have a division bench on. Not single bench supporting.
Please submit again on Thursday.
Much obliged, Lordship. I'll be submitting everything on I'll help you.
Oh, no, it's okay. I see somebody wants to take it.